For the Hansard record, please state your name and the capacity in which you appear.
Christopher Kerin, Kerin Benson Lawyers.
Thank you.
So my name's Susan Proctor. I'm a fellow and council member of the Australian College of Strata Lawyers, and I'm a local Strata lawyer.
Thank you. Thank you, Susan. Please note that as witnesses, you are protected by parliamentary privilege and bound by its obligations. You must tell the truth, as giving false or misleading evidence will be treated as a serious matter and may be considered contempt of the Assembly. If you wish to make an opening statement, please keep it to 1 to 2 minutes, as we only have a short time to get through questions. Have you got an opening statement you would like to make?
Here it is. Sorry.
Chris?
I don't have a brief statement. I'll rely on my submission, which canvasses a range of things.
Thank you.
Thank you. Have you got an opening statement?
I would just like to add that I'm also the co-chair of the Improving Strata Laws Committee of the Australian College of Strata Lawyers, which has recently been constituted. And a lot of the work that we're doing in that committee is cross-jurisdictional analysis of particular policy issues that are impacting strata throughout Australia. Because I strongly believe that we can learn from other jurisdictions and apply relevant contextual improvements and consider in more mature jurisdictions such as New South Wales, Queensland, where there's been a lot of litigation, how particular policy responses have ultimately resolved or not successfully. So I'm very excited about being co-chair of that committee and where that can potentially head in being more perspective in terms of putting forward reform rather than a retrospective addressing an issue.
Thank you.
Type approach.
It's really useful. If it's all right, we'll go on to questions. And this question is for both of you. Anybody can answer. In your submission, you mentioned the concept of fiduciary duty and talk about fiduciary obligations.
We've got two different submissions.
Yes. Can you please explain for the committee's benefit what that means and how this is supposed to govern the way in which strata managers to act in relation to owners' cooperation, or say how an executive committee is supposed to act in relation to the whole OC or even the developer in relation to the OC? So basically, what is the fiduciary duty as it applies to the strata manager? What is the fiduciary duty as it applies to the owners? And what's the fiduciary duty as it applies to the developer?
So as we're not together...
Oh, anyone can answer. Anyone.
I mean, so fiduciary duty is simply a concept of law. There are different levels of obligation. So, you know, the lowest level is kind of a duty of care between people who are strangers, then contractual duty, and then at the highest level is a fiduciary duty. And people who have fiduciary duties have to act in the best interests of the person they owe the duty to. So it's a concept that applies across a whole range of areas, not just strata. Strata managers as agents to a principal, being the owners corporation, owe a duty to act in the best interests of the owners corporation. Executive committee members have fiduciary duty to act in the best interests of the owners. Developers do have a fiduciary duty, but it's probably limited in its scope.
And how would that duty play out? So where would we be looking? Would it be in the materials that are provided?
So fiduciary duties are under the common law. So most professionals will have fiduciary duties where they're acting in a professional capacity representing another party's interests. So the public trustee, solicitors, real estate agents, any professional that's entrusted with a duty from another party and to act in their best interests, as Chris has said. So the common law exists throughout, and in many jurisdictions there have been imported provisions into our legislation to remind parties of their fiduciary duties, and our code of conduct goes somewhat to reflect fiduciary duties in being informed, being educated, not acting in your own interests. So, I mean, it's a principle of law, it's a fundamental principle of law. I think where it gets complicated is that it's not a principle of law that's commonly understood by strata managers in terms of their obligations. So often where there is legislation or where there are education materials, if those parameters don't spell out the extent of an obligation, it might not be possible for someone that hasn't studied fiduciary obligations at law school to understand the breadth and extent of how the common law would respond to that. So I think, most jurisdictions within their strata legislation will reflect the fiduciary responsibilities between the different parties that you've reflected on and through the agency legislation. But the understanding of what that actually means in practice is where there's failings, I think.
And what do you think we could do to improve that understanding in the current structure?
Simple education tools. And I know through the college, what myself and my fellow strata lawyers are looking to do is trying to provide that information by real examples of what could look like a breach of a fiduciary duty, and the concepts of commissions comes up, and understanding what that is and what that isn't, and when or not you may have a conflict of interest. Are common examples of where there can be breaches of fiduciary duties that might not fit neatly within legislative parameters, but are indeed still breaches of fiduciary duties. So I think using examples and simple education tools to say what's okay, what's not okay, ultimately would be useful in terms of educating the sector as to what is and isn't appropriate.
This may be an entirely self-serving comment, but I wrote a book, The Guide to ACT Strata Law, which published in December last year.
I think there's some product placement, it's over
Oh,
there.
excellent. Let's get that on camera.
Slightly self-serving.
So, I mean, in the last 6 months, almost 200 copies have been sold. So that is a tool that I've written expressly for owners, executive committee members and strata managers.
I think it's the job of ACT government to look at providing those educational tools and to provide them free. I think that is an appropriate way to ensure that the knowledge is available to all at different levels within this organisation. I think I've read Chris's book, I think it's great. I haven't read the latest edition, and I'm not saying anything about that at all, other than, I mean, I'm not denigrating it in any way, shape or form, but I do think reading legal texts as well is perhaps beyond even some of our more experienced strata managers in understanding what is and isn't okay. So very simple, straightforward, plain English guides is what I think we need on particular issues. And I think from my own experiences through challenges in ACAT over what isn't common property, some things that you should think would be a straightforward answer within the legislation, it's not. It's complicated. It's clunky. We need to have legislative reform to improve those aspects of our legislation, and then we need to have easy to understand guides that might mean that we're not clogging up ACAT with arguing over responsibilities for certain aspects of things as opposed to others.
Thank you. I've got plenty of questions, but I will move on to Tamus because I know there
First question to Ms. Proctor. You may or may not be surprised, but quite a lot of issues around governance capacity of executive committees have been raised in submissions and also during our conversations this week. Knowledge gaps, lack of education, the best way of using that information, which we've just discussed. But with the training, there is a real divide between mandatory, whether the training should be made mandatory and this is what is required, and then will that have impacts on whether or not people put their hands up to be in executive committees, or suggested voluntary, you might get more people doing the training, but or not depend. Yeah, where do you sit on that?
Yeah. Happy to respond. So the owners' corporations that I act for are often coming to see me because they're challenged with difficult, significant issues, multi-million-dollar building contracts, cladding issues, complicated funding approaches, how to deal with the concessional loan scheme and other things, complex situations that many lawyers wouldn't be able to pick up easily in understanding how the Unit Title Management Act can respond to that. These are 100% complicated issues that no one committee or strata managers should have to bear alone. The way I'm trying to move with a lot of owners corporations I represent, where there is a struggle with getting rotation of executive committee members and enough support for people wanting to put their hand up and enough talent to get that talent to sit on the executive committee level, is to look at incentivising that role by discounting levies for executive committee members. So I think, and there's realm to do that under the Unit Title Management Act. If the Owners Corporation in general meeting so choose, they can allow a discount of certain amounts, and they can allow a discount for people that sit in the role as an executive committee member. And that might make it more attractive to put your hand up to sit on the committee. It might attract people that don't necessarily have the skills you want to sit on a committee, but it might give you enough of a pool to then elect on skill sets in certain types of owners corporations. So that's one potential solution. Doesn't directly respond to your query, but I think
We're happy to listen to solutions or potential solutions.
Allowing for access to free education online materials. Most people who put their hand up to be an executive committee member want to do it for the right reasons. They would want to inform themselves in the simplest way possible to understand what their duties are. And if that was accessible, I think that they would do it. Whether it's mandatory or not, I think you have the problem that Chris has identified. There's potential turnover annually of EC members.
Churn.
Yeah, so the content of a course, the time frame of a course, when it would or wouldn't be mandatory, those sorts of things. But I don't think it should be at any cost to the proponents to go through that process.
I've got one more from Mr. Mr. Kerin, the specific reforms or mechanisms that you might recommend to improve transparency and accountability in financial dealings between strata managers, insurers and owners corporations. Are there, because you mentioned concerns about the limited disclosure requirements for commissions and potential conflicts of interest under the current legislation. Are there specific reforms?
Well, the current legislation does not really set out any sort of regime for disclosure. The New South Wales legislation is quite onerous and has been made even more onerous as a result of the two ABC programs that ran last year and the political reaction to that. But there's a significant gap between the New South Wales and the ACT legislation in that regard. It wouldn't be outrageous for the ACT to move in that direction, but I wouldn't go as far as New South Wales has gone.
Okay, thank you.
Yep, Mr. Rattenbury.
Thanks both for your submissions. They provided lots of interesting points. I might a few questions to whip through. Mr. Kerin, you spoke in your submission about the code of conduct and the possibility of penalties for breaching the code of conduct. Our previous witness actually outlined a view that he thought the code of conduct could do with elaboration. It was really written a bit for lawyers because it's in a lot of concepts that lawyers understand but perhaps EC members don't. Do you have any comment on whether you think the actual code of conduct needs elaboration? And then secondly, when you talk about a penalty, what sort of penalty would you have in mind?
It's not uncommon for people to come to me complaining about the way EC members have behaved. That of itself doesn't necessarily mean they're guilty of a breach of the code. There's a lot of it is personal animus. I mean, that's just the nature of strata.
Luckily, we don't have that in.
No, well, so
Nature of people.
Yeah.
So there have been a number of attempts, maybe 3 or 4 that I'm aware of, where people have sought to have ACAT make a finding of a breach of the code. They've all failed. I'm not aware of any finding by ACAT where someone has been found to have breached the code. But I've always said, well, so what? If someone breaches the code, what then? There's no sanction or anything. And so people can effectively do what they like. So there should be some sanction, but I mean the reality is it shouldn't be. It should be not a large amount of money. It should be sufficient.
Should it be money though, or should it be removal from the EC? I mean, this is an interesting question, I think.
ACAT has, in a couple of decisions, kind of shown reluctance to make findings to prevent people from being on the EC because of the limited pool and the nature of it being a democrat. I wouldn't go down that path. I think a financial penalty of, a number, $1,000 or $500, I think that's sufficient for most people.
Did you want to comment on that at all?
Yeah, look, I've recently presented a paper at the latest Axel conference with another lawyer from New Zealand, and New Zealand have just adopted a code of conduct, and they've looked at ours in their unit title legislation, and it's interesting as to whether or not it's aspirational or whether it's enforceable. So totally agree with Chris, it's not enforceable in the sense that there's absolutely no ramifications for breaching the code pursuant to the legislation. Most strata managers and executive committees find that out along the process when something terrible has actually occurred, and that they're sort of powerless to put into effect any meaningful change. And I've certainly been through processes where strata managers in particular have not been licensed, doing the wrong thing, restricting the role, trying to serve their own self-interest in maintaining the book by continuing on using influence, all acting in breach of their potential obligations. It's a rare occurrence, but it has happened. And then the relevant regulatory authorities just really feeling that they didn't have any powers to do anything about it through the Agents Act and ACAT, not through UTMA. So, yeah, what is the point of a code of conduct? That's the first consideration. Is it there just to provide some guidance as to what is right or to wrong, or is it there to actually have some effect? If it's to have some effect, then perhaps a penalty needs to be attached to it or some sort of consequence for a failure to breach. But at the moment, it doesn't serve either of those functions.
Thank you. Mr. Kerin, in your submission you had some input on decision-making models, which I particularly welcome, because I think you went to some of the issues we had in mind in having that in terms of reference. Specifically, you talked about amending the quorum provisions where people have got an absentee vote. And your argument, as I understood it, was they've essentially participated, but they're not counted as part of the quorum.
Yeah.
I guess my question is, are there arguments, it seems on the face of it a good idea, are there arguments why that would be unpopular or problematic?
I'm not aware of how this occurred. Sometimes this is a bit of an anomaly, I think.
ACT is one of a few jurisdictions that has a quorum requirement.
Right.
Yeah. Okay. In the similar fashion, where there's then a 28-day period that you could potentially challenge a decision, and the bizarreness and ridiculous of that arose in the Manhattan decision in relation to undoing or unpicking prior decisions that were actually made and acted on, which is unscrambling the egg type issues that just shouldn't be a burden on owners corporation to have to be concerned that if they do have something that warrants taking it to ACAT, that it's not going to get kicked out of ACAT or an absurdity arise where an administrator is appointed and it all has to be redone.
I also appreciate your evidence just on the scale of the strata commissioners in New South Wales and Queensland. It's been a big discussion over the last couple of days, and it's very useful to have those figures, so thank you for that. Ms Proctor, in your submission, you specifically raised the issue of, in mixed-use buildings, owners' corporations being able to pass on increased costs to specific units where commercial activities impact on insurance premiums and other issues.
Yeah.
Again, this has come up. There's been a few live examples in the ACT.
Yes. Yeah.
Is this currently allowed under the law, or does it need a specific legislative change?
Well, I believe it's allowed, and just some background, I was part of the ACT legislative reform process from 2014 onwards in terms of the amendments that came out to the UTMA in 2020, and those amendments specifically altered the provisions of Section 78, 2B and 3, where previously, and this is unique, so the ACT is actually unique and forward-leading, very proud of in this particular
Better than
aspect.
the last example, yes.
Yes. Well, that's just errant bad people. That can happen anywhere, right? But in this situation, well, not what we did was we got the legislation to a point where now the owners corporation can decide by special resolution, not as previously required unopposed resolution, to adopt a levy methodology that provides for an alternate basis for applying levies. And there's parameters written into those provisions that state what needs to be taken into account in considering introducing a formula or a rule that considers the structure of the unit plan, the uses of the unit plan, the location of buildings, those sorts of things that could mean that, for example, you take a apartment tower, you might have within one owners corporation, within one units plan, some townhouse type apartments, and you'll have an apartment building. The townhouses largely look after themselves and have no access to the apartment building or the air conditioning, the lift or the services that are lighting the basement, those sorts of things. So it might be appropriate in that situation to look at a split levy methodology where these guys pay for the costs that are associated and that they are directly benefiting from for their particular part, and certain aspects that are only benefiting the unit owners in this particular part of the building contribute to that. And then there'll be common costs that all should contribute to, so the insurance and the auditing fees and the accounting fees and the legal fees, and that all might be appropriately done on a unit entitlement basis. But the impetus and the policy behind looking at those considerations was to allow for greater flexibility where there is a retail element downstairs that are utilising the tradeway services and other particular services, and perhaps not the residential. It was born out of a decision that we were on either sides of some time ago, that particular reform, which was, it's been useful, and there's certainly owners corporations looking to utilise that. But I raise it specifically in my submission in relation to insurance hikes, and insurance is an issue. Insurance is an issue for many different reasons throughout Australia in Strata. So in different jurisdictions, we're impacted by different climatic events that have caused some buildings to be uninsurable, which has led to legislative reform where there is a discretion to opt out of the mandatory regime for insurance in the event that it's too expensive, too cost prohibitive, or not possible to place in an insurance. So you're not in a situation necessarily where all the lot owners would be in breach of their mortgages over their units. We've seen similar issues in the ACT, not with cyclonic activity, but with the cladding, now tobacconist. So if you've got a tobacconist that comes into your unit plan, straight away, if you can maintain your insurance, it's going up. So that use that might be permittable within the context of the units plan and the Crown lease permitted use is giving rise to an actual hike in the premium. So, I'm trying to work with... There hasn't been any decisions as to ACAT considering the application of split levies and how different rules are drafted to accommodate these things, but that's certainly what I'm trying to assist owners corporations to do. And at the end of the day, I think we need to be looking at ensuring that our strata sector is an attractive place to move into. We don't have a heap of revenue coming into the ACT. We need to utilise our land as best we can. We don't want to have big concerns over and risks associated with buying into strata. So we need to look to assist rather than overly regulate. We need to find those parameters that we can give owners corporations to self-govern in an appropriate fashion.
Just got one more quick one. We had some fairly eye-opening evidence this morning from Care Financial, who talked about the fact that in the ACT, 21% of all forced bankruptcies were stratas pursuing late fees from owners and driving people into bankruptcy. I guess I'd be interested if either of you, in your experience of the ACT, and that was well above the national average of 10%.
Yeah.
I'm interested if you have any reflections on the culture of the sector in the ACT as to why that's the case. And the specific proposal they put to us was that we should have hardship provisions in the territory to enable a more nuanced approach to the recovery of debt. You're probably coming at this from the other side, but can you offer any reflections on that issue?
I mean, I can't talk to Susan's practice, but there's a practitioner who is not in the ACT who does most of the levy recovery work around Australia. And so I'm surprised that there's a differential, because I would have thought he would have he would treat all jurisdictions the same way. So whether he's doing levy recovery in Queensland or New South Wales or the ACT, he's applying the same sort of standards. So I'm a bit surprised.
I think the argument was compared to some other jurisdictions, we don't have a hardship set of rules which requires people to think about repayment opportunities, repayment programs and the like. Seemed to be the reason we were given for the difference between the local and national average. But
yeah, I mean, typically, in my experience with levies, owners corporations will enter into payment plans. And so this is not legislated, it's just kind of, we'll help and pay it quarterly, and if there's a default, then we'll start again. Mm-hmm. So that, in my experience, has been a norm. I can't talk because I don't do much levy recovery work myself. As I said, my understanding is the dominant provider of that service is based elsewhere.
Okay.
Yeah, I don't do debt recovery work. I'm not a litigator and I don't do that sort of work. And I understand that a lot of the firms that would get engaged in that sort of work are firms that often are appointed by the strata manager and might have a national relationship with doing that work en masse. Mm-hmm. Because it's the sort of work that is quite low fee and it's transactional, just a set of steps, and
like conveyancing.
It's high margin, low margin, high volume work.
Yeah, so I think that statistic does surprise me. The introduction of a hardship element, I think, can be complicated in terms of the definitional elements. I've seen it attempted to be done, albeit I think not successfully, through the participation agreements through the cladding concessional loan scheme. I've raised questions as to whether or not that's actually possible. I don't think it is under the Unit Title Management Act, because the way that our legislation's drafted is that as the former speaker was commenting, buying a unit's like buying shares in an unlimited liability company. So the owners corporation has an obligation to pursue its owners to pay its expenses. That's its statutory function. It has to do that. If it has expenses to pay, which it will, it has to ask the owners to do it. And if there's all but one left, then that poor mug's going to have to pay. So my recommendation often is, if you are looking at buying a unit in a unit plan, you want to make sure that you've got some well-heeled people around you, just so you're not necessarily the last person standing. But I know.
Winning of units, probably.
I know, it's sad, but if we can't look to find some way to deal with that imbalance as well. So if 50% of a owners corporation fit within a hardship scheme and stop paying their levies, then the other 50% are going to have to pay it.
Yeah. I think
the costs don't stop coming.
It is common for payment plans to be entered into. I've seen this particular firm do that on a regular basis, and then there's a problem because they don't comply with the payment plan. So I was surprised. Gary actually mentioned that to me before we came in. I was surprised to hear that. I'd like to see some granularity around it. Yeah.
One last question. I know we're running out of time, but I just thought it would be remiss of me if I didn't ask this question, considering, Susan, that this is your space. What are the key issues with the Unit Title Acts? Like, if there are a few things, few provisions that you can change that really icks you, what would they be? And what would be your suggestion?
Look, I think we need to look to, not to directly answer that question, but I think we need to look to appoint a Strata Commissioner to have someone that understands the nuances of the problems in our current legislation, the rest of ACT government, and the interactions between departments in terms of planning, tax, Building Act, liability, insurance. It's across everything. Like, Strata is a very complex beast. The UTMA tries to just help owners manage issues, but it doesn't deal with the myriad of problems that impact Strata. And so my solution to that in my submission, which I forgot to mention, was that I know that we're kind of short a few penny in terms of the budget for ACT government. So how do we fund the Office of the Unit Titles Commissioner? My preference would be, rather than Strata Commissioner. Why don't we look to, we've got all these strata managers and owners corporations sitting on buckets of money that aren't in trust accounts. Now, lawyers have regulated themselves over the years to ensure that we've got appropriately skilled professionals in the roles of fiduciaries in terms of the work that they're doing. Now, we've got unlicensed, uneducated, potentially strata managers managing massive books, massive amounts of money with no oversight or regulation or regular trust audit requirements sitting over the top of them. So the lawyers fix this for themselves in a way by ensuring that we have to have, if we're holding monies on behalf of someone else, they have to be in trust, they're regulated by legislation, and that legislation means that the interest earned on those trust funds goes into fund the law societies that then regulate our activities. That is a solution to how we can then regulate the sector that I think we should look at. So sorry not to directly.
No, that was really
I have
good.
a quick question on that. I mean, presumably that money now is sitting in a bank account of the owners corporation, and they're generating interest from that?
Well, sometimes they may choose to invest it, but otherwise they're not.
Yeah.
So Macquarie Bank, for example, has targeted this area for probably the last 20 years, and it holds, I understand, holds billions of dollars in strata fees. Because the sinking funds are very large, millions of dollars.
Yeah, no, there's economic opportunity there.
So this
Essentially lazy
Absolutely.
capital.
Macquarie Bank is a large sponsor of SCA organisations and conferences and so forth, and they have a presence there, and they do reports to assist strata managers and so forth, and that presence is linked to the fact that they take large sums of money.
And become the investment managers of those funds.
Yeah, but I mean, we regulate real estate agents in terms of ensuring that if they're investing monies or doing things, that it's going through their trust account, and the interest on those trust accounts is going in through to the compensation fund, which I assume is quite small in the ACT. But we're not doing it for significantly large sums of money, millions of dollars, that are just sitting there and...
Is that money being held by the strata managers or by the owners corporation?
Strata managers as agent for the owners corporation. Yeah. But the owners corporation will often struggle even getting a copy of a bank account that reflects their actual monies held. Okay, so they're in collective pooled funds.
So the owners corporation is not earning the interest?
No,
Sorry.
nobody is earning the interest other than the banks.
Right, I'm being given a wind up here. I can keep going for a while. Thank you.
There's another meeting.
Yeah, I definitely recommend we investigate that.
Yes,
It was
absolutely.
a very interesting part of your submission. Thank you.
On behalf of the committee, I thank you for your attendance today and your contributions. The committee will now suspend proceedings for a break and reconvene at 4:10.
Thank you.
Thank you.
Thank you.
Cheers.